Good afternoon, DAR members. If you could you shake your head if you can hear me? Perfect. All right, great. Great to see everyone. Thank you for joining us this afternoon for our rapid question and answer session. We have a lot of you signed on. A lot of questions have come in over the weekend, over the last few weeks. So our goal today is to tackle as many as we can, as fast as we can. So we're going to jump right into it. First and foremost, though, do not send questions that you have to the Delaware Association of Realtors, to Matt Lafferty. Send them directly to me. So when you open up the chat in Zoom, it says to and then a person. Send it directly to me. It says questions and then Wes Stefanik. That'll go right to me. I'm going to be the only one answering or getting the questions and then sharing them with Bruce and Andy. So with that, I don't think I said it. My name is Wesley Stefanik. I'm the CEO of the association. Thank you for joining us again. I'm here with Bruce Plummer, the chair of the DAR Forums Committee, and Mr. Andy Taylor, who is our association's legal counsel. So give me 1 second. There's some comments coming through about the chat. It only is supposed to go to me. So you're not going to be able to choose anybody else except for a couple people. Only send it to me, and I'm getting questions already, so I know it's working. So with that, I'm going to turn it directly over to Andy and Bruce, and we'll jump right into it.
Okay, thank you very much, Wes. Andy Taylor here to help us through questions and answers, and also to bring you up to date on some other things. But first of all, we are going to assume that you're familiar with the basics of the antitrust lawsuits that have been happening. You're familiar with the settlement that was announced on March 15th. You hopefully have been on some of our other webinars talking about the various forms that DAR has been making available to help in dealing with all of this. And so there's the NAR's role, DAR's role, the forms we've been providing. As you know, those are offered as a member service. They're not mandatory. You layer on top of that, then there's the Delaware Real Estate Commission as the regulatory body over all licensees. And then you have your broker, of course, and company policy and how your brokerage company decides to use various forms or have various forms available for use within your company. So there's all sorts of different players involved in this, all of us working through it and trying to figure it all out together. And speaking of the Delaware Real Estate Commission, let's see, Wes, may I share my screen? Here. Just, the CIS is being revised to recognize the customer level status could be more available, could be requested a little bit more by a member of the public, and to have the compensation language in here. So this is being posted very shortly on the Real Estate Commission website as a revised consumer information statement. You'll see I've shown on the screen a highlighted version. So there's the compensation right up here towards the beginning, making sure the member of the public knows broker and agent compensation is not set by law and is fully negotiable. That's part of what helps to comply with the antitrust settlement agreement of making sure the member of the public is advised of that. And there's not a quote standard commission. You, meaning the member of the public, should discuss compensation and the scope of services to be provided for such compensation with your real estate agent early in the process. Brokers can set their own compensation and fees based on what services are offered and their business model in the competitive marketplace. To protect your interests, it is recommended you enter into a written agency agreement outlining your real estate agent's duties as well as your rights and responsibilities. And there's some very similar language in the DAR forms that you've already seen. Now, the customer level status is not new in the Delaware Licensing Act. I was actually a little surprised myself when I pulled up my Word version, put in the find for the word customer, and it's just all over the place within the Licensing Act. It was already in the CIS, you'll see, as a definition here of a customer. So a customer is a member of the public who's working with a licensee before the presumed agency relationship begins, or who declines agency representation, which means there's no duties other than confidentiality. So that was already in the CIS. So remember, if for some reason a potential buyer is not becoming a buyer client, if they're remaining a customer, maybe just for a little while, you still owe them a duty of confidentiality. And then on page 3, a space put to recognize here, I am the buyer. So over here to the right is what's new. The third status, not my agent, I'm only a customer. Prior to this being in the form, if someone was not a client as a buyer, but just a customer, you would have had to write it in the form somewhere, which is very rarely done because most all buyers saw the advantage of being represented by an agent and being a client rather than a customer, but it might be asked for a little bit more now. So, and DAR is going to send out these highlighted versions for you as well. So since that's brand new, we wanted to use this as the opportunity to bring you up to date on that. When those do hit the DPR website, you can go ahead and start using those right away with new clients and customers, listing sellers and buyers, and use it. You do not have to go back to existing customers or clients and give them this revised CIS unless they were choosing to change their agency status for some reason. So that's your update there with that. Now, Bruce, we put together a whole lot of forms. I know the forms committee has met more times than I think we can count. And I thank you for that. And I don't know if you want to mention the forms committee anymore. And then I have a couple of questions for you about the forms that have already been released while we have some questions coming in and Wes organizing those to get us started.
Okay, Andy, I think as we've mentioned before, there's 2 representatives from each county In Sussex County, it's myself and Camilla Conlon. In Kent County, it's Bobby Slagle and Tom Burns. And in Newcastle County, it is R.T. Christopher and John Ford. So each county is represented, and you can talk, if you've got forms questions, you can certainly talk to any one of those. Doesn't have to be someone from your county, but there's 2 agents from each county on the committee. And they have put in a lot of hours, if you've suggested.
And that committee is very careful about reviewing every comment and question that comes in regarding the forms. And maybe you send in a question or a comment about the agreement of sale. That doesn't mean you're going to see it tomorrow, but we keep all those comments. And then when we have a batch of those, time to revise the agreement of sale, we go ahead and review all of those.
I just entered one in my database this morning. That came in over the weekend. Yes, we do keep them all.
So Bruce, suppose I'm a potential buyer and I get in touch with you. Hey, Bruce, I've heard good things about your work. You worked with a friend of mine and I'm looking for a home. How's this work now? I've heard there's some antitrust case or something, or there was some case in another state. So what do we do now?
Well, when a buyer comes in, you're going to, of course, have to use the CIS. That statute hadn't changed.
Right.
You'll have to give them a CIS at the first scheduled appointment, first showing of a property, or before they enter into a brokerage agreement. It has to be signed before they enter into a brokerage agreement. And I would point out that a buyer agency representation agreement is a brokerage agreement. So that does trigger it needing to be signed. Of course, now, in addition to the CIS, if they're going to be touring properties listed with other brokers, you're going to have to give them the Bright MLS disclosure.
Okay.
Buyers will be given that, and they'll initial the top half, the top section. Now, interestingly enough, that goes into a little bit of disclosure of the settlement, and it does make the buyer aware of the fact that they must sign a written agreement before touring properties. It also tells them that they can include the fee, the buyer's agent's fee, in the offer when they decide to make an offer. So it reinforces everything, and that's bright. And then, of course, we're going to talk about a representation agreement.
Okay, tell me about that.
All right. So buyer representation agreement. This is our form now is a new form, but it goes into more detail. It says exactly what you can expect from me. Here's my services. Here's what I'll be doing on your behalf. It says here's what I charge. It makes it very clear, and I would point out to the public when you're explaining this, it says right here, see, you can include that in your offer. A lot of buyers are asking that question, but it says right on the buyer agency agreement that you can include it in your offer. And then I would even have a copy with me when I talk to a buyer of the sales agreement. Normally, I would give them a copy of the sales agreement to look at anyhow, because this is the form we'll be using. But I would highlight the section that says, here's the section for it. For instance, here's the agreement of sale. I would take them right to section number 29, broker compensation, and explain that to them. So hopefully they're comfortable with the fact that, yes, I've got to have a written agreement. Yes, I can include that compensation in my offer. I don't have to pay it out of my pocket necessarily. And then I would review it as an exclusive agreement. I'd say it goes over how we can cancel it, how much notice you have to give, those type of things, what territory is for.
And that's a blank that can be filled in. And
yes.
Now if somebody just met you, great, you worked with my friend. I heard really good things about you, Bruce, but I'm just meeting you today. What can we do?
Well, and I think that's when you're working with a past client, of course, it's not an issue. The form we have is an exclusive right to represent. But I think it's not unreasonable to think that a new person that you're meeting the first time may say, wait a minute, I don't know you. I'm not going to sign an exclusive agreement. I'm not going to be bound to pay you a commission and work only with you for the next 6 months or something. So the form itself is a exclusive right to represent. But Andy, it's got blanks where you can do for instance, the term. What's the expiration? You could have it expire in 1 day.
Okay.
You could have a cancellation provision. Suppose you're unhappy with my services and you want to fire me. You could put 1 day. There's a line for cancellation.
So I can sign this form with you today, but I could cancel on 1 day.
You could cancel it this afternoon.
Right. Or we could say we're only working for today or
Andy,
tomorrow.
You could say just today. You could even say, I'm only going to do it for this particular property.
Mm-hmm.
I want to see the property on Mulberry Street. I'm just going to sign this for Mulberry Street.
Okay, that sounds good.
Now, another thing you could do, and I'm telling agents this, if you run into an obstacle, you can certainly make it a non-exclusive agreement. So they're not bound to work with me or you. If you don't know me yet, I'm happy to work on a non-exclusive agreement. We'll put the word non here. We'll go under special terms. We'll make it very clear it's non-exclusive. What else can I do to make it palatable for you?
No, that sounds
You can
good.
cancel the day's notice and you still work with other people if you want.
That sounds good. Let's kind of shift the scenario here a little bit and then we'll get into the Q&A. So suppose I'm a seller and Bruce heard good things about some friends you've worked with, and I'd like to sell my home in Rehoboth. Can you help me out? I don't have a home there, though. Can you talk with me as though I was a seller?
Sure, we can. We'll do our regular presentation and explain our services. We're going to do a CMA and show the comps, et cetera. In the listing.
A little side note here on those CMAs, then, are you going to say anything to me about, gee, this comps I'm showing you from the past couple of years?
They include buyers, brokers, compensation.
Right.
So when we get to the buyer broker compensation part in this listing agreement, I'm going to be negotiating with you for what my service is, what I charge on the listing side of the transaction.
Okay.
We're not going to negotiate yet what we're paying the buyer's agent because we don't have to.
Okay.
First off, we don't have to pay him anything, but I don't recommend that. I'm telling you as a seller, Andy, that when you say you're not going to offer to pay for the buyer's broker's compensation, you greatly limit the pool of potential buyers.
Potentially. Now, I've heard of this term seller concessions. What's that about?
Well, a concession is any type of settlement help. It could be for down payment assistance, for closing costs. It could be to help pay for buyer's broker's fees. So in today's world, you and I are going to negotiate what you're paying me to list your property.
Right.
We're not going to negotiate the buyer's agent's compensation yet because we don't even know what the buyer's agent's agreement says they're allowed to be paid.
So we don't have to talk about that now.
Or we don't have to talk about it,
Okay.
except that I'm going to prep you. Don't be surprised.
Right.
In fact, I will tell you more frequently than not, a buyer is going to ask to pay it.
It's okay.
Whereas before, in the old days, Andy, let's say you pay 8 apples, I'd keep 4 apples and give 4 apples to somebody else. Well, now you and I agree to 4 apples. The other side agrees to whatever they agree to. And if it's 4 apples, they ask that you pay their 4 apples and you're still paying 8 apples. So, but you and I are not going to put your cards on the table on what you're willing to pay. Why would you offer to pay 4 apples to a buyer's agent who's only negotiated a fee of 3 apples? You've just given 1 apple away.
Mm-hmm. Okay.
Why would you do that, Mr. Seller?
I understand that. And it seems to me as well that there's not going to be one pat answer to a seller as far as offering compensation to a buyer's agent. Could depend on, is this property really going to be marketed most appropriately to first-time home buyers? Bruce is probably more likely to talk with me about, be really, really prepared to, pay some buyer agent compensation. Sure. On the other hand, middle market, upper market, move up market, maybe we're not going to be having as much discussion about expecting how that might turn out. So it's all going to shake out in the competitive marketplace.
So don't be surprised. I mean, we're negotiating the listing side.
Right.
But we're decoupling is what it's called.
Right.
That's 2 negotiations. You and I negotiate my side of the transaction as
Right.
the listing agent. The other side negotiates what they're getting paid. And then if they want you to pay it, they'll ask. Don't be surprised, Mr. Seller. That's the way it has worked historically.
Right.
All these comps I've shown you, that's the way it worked.
I see.
So even though we're in a new market, the end result is most of the time, the buyer's agent's probably going to ask you to pay for the buyer's going to ask you to pay for their agent's compensation.
And that would, if I'm as a seller offering to pay that, that's coming off the top. So you're going to help me do some of those calculations.
We're going to do a net
offer.
proceeds.
Okay.
And that way, if you get one offer that maybe is the highest price, but another offer includes, and it has concessions, and another offer doesn't have concessions, and maybe we've got one that has other settlement help or roof repairs, we're going to look at the whole picture. And I'm going to show you your net proceeds, and you can make an informed decision comparing oranges to oranges.
Good, thank you. You mentioned, and you showed me this Bright form. So we talk about seller concessions. How's that appear in the MLS as of today?
Well, today, if you go into the MLS, it will say seller's concessions, yes, no. So a seller in writing is already, with their listing agent, is giving authority to market the property that way. They're marketing it as they're willing to consider concessions. So when you look at that, it says, here's a seller who's already been instructed and considered and is willing to consider paying some concessions. Most probably a buyer's agent would be one of them.
And is it going to have the dollar amount in there?
It will not. It will say yes or no.
So that's something, just new and just confirmed literally minutes ago, that the way then it will show in the MLS, even though Bruce and I have had this discussion, he's prepped me for being willing to pay seller concessions. We may have even talked about some dollar amounts or some percentages or whatever. And Bruce has made some notes about that, but that's not in the MLS. So anyone looking at the MLS then is just going to see seller concessions, yes, no. And that's different than what Bright had indicated, about a month, 6 weeks ago, 2 months ago, that there would be a place to put in the dollar amount. Now there's not. So it's just seller concessions, yes or no, which I think reemphasizes the point. You don't need to be having the seller agree to a percentage or a dollar amount as part of the listing. Just as Bruce indicated, he's prepped me as a seller for that as a concept. We'll see how it happens when offers are made. He's my professional. He's going to do the net calculations for me, help me understand it all, compare different offers. And so we'll go from there. So I'm sure by now Wes has had some questions organized for us here. So let's dive into
We're
it.
about 60 deep. So here we go.
Okay.
Are buyer's agents allowed to discuss buyer agent compensation with listing agents verbally?
I think that a buyer's agent is going to negotiate a compensation package. They can certainly call the listing office and ask them if they're offering compensation or concessions. I think that the way to handle it, though, if you've agreed to pay me 8 apples and I want 8 apples, and the buyer wants to include that in the offer, we put it right in section 29 in the offer to purchase, the agreement of sale.
Yeah, so it's okay for buyer's agents and listing agents to discuss, compensation. Of
Yeah, you
buyers.
can't put it on the MLS,
Right.
but you still can talk about it. Yeah.
So on that point, it can't be on the MLS, but they can share it on their personal Facebook or social media posts.
And the listing broker's website.
If I have a listing and a buyer calls me, do I need to get anything signed by buyer before I show them the property?
If you have the listing, you're still going to need to have a CIS signed because you have to do that before first showing. You won't need the MLS document, I guess, because it's your listing personally. And you could show it without a signed representation agreement, but you're going to want to offer, when you give them the CIS, it says they're presumed to be a buyer, you're presumed to be a buyer's agent, or in this case, a dual agent. And you're going to explain that, and you would offer them the chance to have representation in writing. You'd negotiate that amount. If they're not willing to sign it, then you would be acting as a seller's agent only.
And that's where the new box on the CIS would come into play of having them initial they're a customer only.
They'd be a customer only.
I would like to encourage everyone to also continue to use facts.realtor. Type that into your URL, facts.realtor. They've compiled so many questions and answers. And I'm telling you right now, a lot of these questions coming in are answered directly on that page. So we're going to try to parse through them as best we can. Next question. I have a phone conversation with a potential buyer. Can I send listings, comps, etc.? Can I have email conversations with buyers without a buyer's agent agreement?
Not touring yet.
Yeah, you're not touring yet. I think if somebody asks you a question, you can respond. First scheduled appointment or first showing, you're going to need the CIS, then you're going to get into your agreements and all that. But just responding to an email, you could do that, I think, without. Now, if that email contains a video link to a virtual tour, Bright says you're going to need a written agreement.
Because that's considered touring.
That's considered touring.
Right.
If
So
you've got a
touring
virtual link
versus-
or a link to a virtual tour.
You're doing FaceTime.
And it's not that they went on the website and found it, it's that you sent them that link. That's considered a tour.
You're doing a FaceTime showing of a property to somebody in California.
Correct.
Then that's touring. Right.
So there's a lot of questions that ask, is this legal? Do you want to talk about a little about legality versus settlement and our policies and procedures?
Sure. Are they meaning anything particular that's legal or
Like,
just?
what is this law? Is what
Oh,
we're
okay,
doing in
right,
law?
sure. Okay. So first of all, commissions are negotiable as they've always been negotiable. And the kind of basics of the lawsuit were that they were challenging the NAR policy of offering cooperation and compensation within the listing agreement because they felt that coupled, Bruce had just mentioned uncoupling, but that coupled together the conversations of the listing agent saying that there's going to be compensation paid to a buyer's agent. Here's the amount that it'll be, and that there really wasn't as much of a chance as there could be for negotiation. So then the NAR settlement that was announced on March 15th that covers most all the members here in Delaware. So realtors who are members as of the settlement date notice, which could have been as early as the 17th. It's going to be sent out very soon to members of the public to notify them about the settlement. Realtor members at that point, pretty much here in Delaware at least, are pretty much all covered. In order to be covered by that release, you then have to be complying with these practice changes, which is what we've been putting into place with the forms and everything that we've been explaining. So I don't know if that helps address some.
Yeah, I know a couple of these questions. So some states we know required in law written buyer's agency agreements
Right.
previously for years.
Right.
Delaware doesn't have that.
Unless you're seeking to form an exclusive buyer agency agreement with compensation, being paid. So,
And we are looking at that maybe possibly in the next legislative session to do a little more on that front.
right.
Next question. Can an agent put well, I'm going to ask it the way it's written. Can an agent put buyer agency compensation in the listing agreement? For example, in paragraph 25 of the new listing agreement, can we put seller has elected to offer buyer broker compensation of X% of the purchase price? Seller offers listing broker to advertise and market buyer broker compensation.
Well, they can't market it in the MLS, but they can do that. Our forums, we're not necessarily encouraging that because we're taking the decoupling approach. But the NAR settlement agreement would allow you to put under special terms and conditions that you are offering compensation to a buyer's agent.
If I have a buyer agency agreement signed with my client, but need another agent in my office to handle a one-off showing for me, do they need to get a separate buyer agency agreement signed, or is this covered in section 22 and nothing more needs to be done?
It's covered by being able.
Yeah, I think it says you can appoint another agent in the firm to assist on those type of duties.
Right.
All right. Do we need to provide buyers with the new Bright form as well as, of course, the buyer agency agreement?
Yes, the CIS, the Bright form, if you're going to be touring homes that are on the MLS, and the buyer agency agreement or some type of written agreement.
How long do buyer's agency agreements need to be on record for? How long must brokers keep them?
I don't know that there's a statute or anything that says that. Most brokers, I've heard some say you got to keep records 3 years. I don't see, in some cases like CE credits, it tells you for CE certificates, you have to have the current licensing or CE period plus 3 previous years, I think. Also, your escrow, I think it says 3 years. I think most brokers try to keep things for 7 years. I will tell you, if you use dotloop, which is one of our forms providers, it archives everything for 7 years automatically, anything that's in dotloop. I don't know about DocuSign and BrokerMint and some of the others, but I do know that's the case with dotloop when we negotiated a contract with them.
You guys did touch on this a little, but I'm going to ask this question. Can you please dive into sub-agency more? It's only been briefly mentioned in our past discussions, and I recently ran across the instance where it would be needed. How is the compensation broken out for sub-agency? New form only has listing agent and then asks if they will allow sub-agency.
Want me to answer it or you want to? Okay. So if a buyer elects that they do not want representation, one option would be if the listing office is offering sub-agency, you could be a sub-agent. Now, a lot of agents don't understand sub-agency because we didn't do away with it, but we had presumption of buyer agency when you're working with a buyer for the last 20 years or so. And so they've never acted as a sub-agent. But a sub-agent, the principle is the seller hires an agent, and then the agent hires a sub-agent, an agent from another firm, who is still representing the seller. No one's representing the buyer. Everybody in the transaction is representing the seller. So yes, if the listing office and the seller were offering it, you could be a sub-agent.
Correct.
Now, you have to be careful when you're a sub-agent because when you're asked questions, you're not a buyer's agent. We're used to answering questions. I'm your agent. I'm going to help you. And well, I'll give you factual information, but I'm not here to be your advocate to get you the better deal.
Right.
As a sub-agent, I'm working for the seller.
And let me chime in there. That was one of the main things with the Delaware Statutory Agency when that went into effect in 2007, was to try to help avoid those unintended agency relationships where a licensee, as Bruce indicated, was working with a buyer. They didn't think they were working for the buyer. They thought they were only working with a buyer, but actually being a sub-agent of the seller. And that's, in my view, very hard to do for any really length of time because that buyer then starts asking for advice. Well, what do you think about this? What do you think about that? What are you seeing now in the marketplace with this? Or what do you think? How's this going to be when I go to resell in 5 years? Because I know I'm going to be relocated again. That's asking for professional advice. That's not just factual information of how many bedrooms, bathrooms, et cetera, does this home have? So that then you're getting into, if you look like a duck and quack like a duck, you're a duck. So you're starting then to act as really in an agency relationship, and yet you thought you were just trying to be a sub-agent of the seller. So in my view, it's much better to do, as Bruce indicated in the beginning, go over the buyer agency agreement. You could make it non-exclusive. You can make it for a day. You can make it for a week. You can make it whatever time period with a short cancellation time period. I think you can get me as a buyer to be comfortable with that and to say, I'd much rather represent you as an agent to be able to give you advice. And then there's still confidentiality. Even if you canceled tomorrow, there's still confidentiality between us.
And then I think the question also said, well, what are you going to get paid as a sub-agent? Well, that would be, you'd have to contact the listing office and see, assuming they offer sub-agency, what compensation are they offering? You would have to check with them.
Back to one of the previous questions, and just to be clear about it. So the buyer agency agreement has a designated agent. If that agent is not available to show a home and another agent in the same brokerage is showing the house, do we need a new buyer agency agreement?
I think we covered that a few minutes ago. It does say that.
Down towards the bottom. Yeah.
Yeah. Other agents of broker may assist designated agent as authorized by broker. So that is in the buyer agency agreement. Yes, another agent in your firm could do a one-time showing or assist on your behalf.
If we show a listing of ours as a listing agent, we do not need to have a buyer's agency signed, correct?
Well, you still need to give them the CIS. You don't need to give them the MLS document because you're not going to be touring any MLS properties. You're just showing them your property. But when you give them the CIS, you're going to have to give them the opportunity to have representation. And if they want representation, then they're going to negotiate a written representation agreement with compensation. If they don't want to do that and they choose to remain unrepresented, they would check the CIS that they're unrepresented, and then you would proceed as a seller's agent only, even though you had that side of the transaction as well.
What happens then if buyer wants to use listing agent to write the offer after the showing?
You can do that, but you're not giving them any advice.
Yeah, you can certainly sell them a property as a unrepresented buyer. You can do that.
Some of these I think we covered, but I'm going to ask them just to go through them. Can we put in our company listing agreements how much the seller is willing to offer to a buyer's agent?
You can do that. The form is not designed for that, but it's got additional or special terms, and you could put it there. Nothing in the NAR settlement agreement prevents you from doing that. It gets away from the decoupling that the Department of Justice wants, and like we're trying to, the direction that we think we should be going. But you could do that. If you were going to do it, you'd put it in special terms.
Can you provide clear?
What your seller be doing, he'd be putting his cards right on the table, what he's willing to pay before he even knows what the buyer's agent's authorized to collect.
Can you provide clear guidance on how agents should be explaining arbitration and the class action portions of the listing agreement and EBA forms?
Sure. So we put into the forms a yes or no box. So you explain about rather if there's a dispute between the member of the public and the licensee, that they're agreeing by that agreement that they would arbitrate that between them and not be going to court and not be participating as part of a class action lawsuit. It's like, hey, if we've got a dispute here, first of all, let's talk about it. But if we really can't resolve it, then rather than going to court, let's go through arbitration according to the Delaware arbitration statute. The member of the public does not have to agree to that. The broker doesn't have to be agreeing to it. And if you don't want to do that as a broker, if you'd rather litigate, you can just check off no on that.
And if no box is checked or no line is checked, then it's not included. That's the same as a no.
So there's questions about the CIS, back to Andy's presentation about that. Our understanding is the Real Estate Commission will be sending that out to all licensees.
Well, they'll be posting it.
Oh, posting it. Okay. Posting it for all licensees to see, publicly available on the Real Estate Commission's website. So not entirely sure when that's going to happen. Supposedly it's today. But I think that answers all those questions.
Right. And DAR will send out the highlighted version that I showed you, and I wrote a little explanation and some further background about it as well.
If you draft an offer for an unrepresented buyer on your listing, does that fall within ministerial duties? And as long as at least one of those participants is realtor represented, is it okay to use DAR forms?
Yes, if the DAR forms are designed to be used when there is at least one realtor member involved in the transaction. Other than that, they are copyrighted forms. So as a real estate lawyer, I handle settlements and represent buyers and whatnot, but I'm not a realtor. So if somebody contacted me without a realtor involved and asked me to draft an agreement of sale, then I would not be using a DAR forms.
As the listing agent, you are able to show a property to an unrepresented buyer that has not signed a buyer agency agreement. Would this apply to all members on that listing agent's team? And one step further, would apply to all agents in that brokerage?
The buyer is completely unrepresented.
Yeah, the buyer has no representation. Doesn't matter whose listing it is. The buyer remains unrepresented.
You'd be filling out the CIS showing the customer.
And if you do that, as Andy suggested, you want to make sure you get all your paperwork in order, your CIS, and make sure it's signed or initialed correctly that they're unrepresented.
Can we get DAR to provide a broker-to-broker agreement?
Well, I don't know. The Forms Committee will have to talk about that. You mean a broker-to-broker compensation,
That's what it sounds like.
which is if a broker elected to offer compensation and put it under special terms, and then another broker were to sell that property and want to make sure they got paid that compensation if they were told they would get, they could use a broker-to-broker compensation agreement. We did not do that initially because we anticipated the compensation being built in the offer in the agreement of sale. But if you chose to do it that way, you'd need an agreement. I suppose we can discuss that.
As the listing agent, you show a property to an unrepresented buyer with no buyer's agency agreement and have provided them with a CIS that says you only represent seller. After the showing, this buyer wants to make an offer. Are you able to then revise the CIS as you would then be acting as a dual agent?
Yes. Yes, you could do a new CIS then to check off that that then the buyer would not be initialing any of the boxes here because they'd be reverting back to the Delaware presumed agency status of agency and presumed consent to dual agency.
Yeah. But now remember, if they're going to be a dual agent, they're going to have a written agency agreement for their side of the transaction too. So they're going to get to negotiate with you what they're going to pay on that side of the transaction. So you not only need a CIS, you need your buyer agency agreement.
Excuse me. Okay, please tell us how we guarantee our commission from broker to broker now that it is not in the MLS. Do we use the agreement of sale as proof of what we are to get paid from the seller's agent? Now the settlement company, law firm will use the agreement of sale as proof to what we are getting paid along with the buyer's agency, correct?
The broker to broker compensation that we talked about a second ago, that form would take care of that. That would be a contract between the brokerages.
So they're saying it's the compensation's in the agreement of sale.
And in the agreement of sale, the broker's not offering compensation. That's the neat thing that I don't think brokers are fully understanding. In the agreement of sale, the broker offers no compensation. Don't come back to me and say you're the procuring cause, you want to arbitrate, and you're coming after me because I offered you. I didn't offer you anything.
It's the seller.
It's the seller.
Right.
It takes that off the broker's back.
Makes it easier.
Much less liability that way for a broker.
I just want to remind everybody, we're getting a lot of comments to the wrong place and we're not looking at those. So just keep that in mind. Please send them only to me. It says questions and then my name. I believe a lot of people are sending them to the one that says Delaware Association of Realtors. Do not send it there because we're not going through those. All right, next one is please explain page 3, 12B of the exclusive right to sell listing agreement regarding sub-agents. I think you guys might have touched on that, but that's the exact question.
Yeah, so that's where it says that we're authorized to work with buyer's agents. That's a given. To cooperate with them. And then it says cooperation. Now, cooperation compensation, two different things. We're authorized to cooperate with sub-agents. And this is where the seller and the listing broker would have yes or no. And then they would go into the MLS and make sure they put the same thing, that they're offering compensation or are offering cooperation to sub-agents. And of course, the sub-agent is then working for the seller.
If a seller says no to seller concession, does that indicate that the seller would be offering a % for buyer's agent?
They said no.
No, if they wanted to offer a %, they should check yes. If they said no, they're not willing. It's saying, now, let me preface this, it's saying that they will not consider giving any concessions, including buyer broker compensation.
But Bruce, I still want to see that property.
Yeah, show them the property, take them an offer, and then with the offer in front of them, see if they'll take it or not.
Right. My price might be so good.
Yeah, you know, the old saying, buyers are liars, well, sellers are too. So,
Andy, could you dive a little more into what actually is ministerial tasks?
Yeah, I mean, ministerial acts is within the licensing act as far as just the kind of the nuts and bolts things that you need to do. It's really contemplated to be after an agreement of sale is signed and just some of the nuts and bolts to work through the particulars and get to settlement.
So the question is, please define representing an unrepresented buyer. What is the limit of what should be done?
You can offer facts, so publicly available facts, how many bedrooms, bathrooms, where is this located? What school district is it in? Well, how good's that school district? Well, no, you're not answering that question. And you refer them to the school district's websites for information about that. And so it's really, you can provide them with factual information, but really not your professional advice about things.
How can I share something that isn't in the listing agreement about the amount of buyer agent compensation?
Well, if it's not in the listing agreement, you
then
don't,
you're not authorized to share it, period.
then you make the offer and put it in there. Yeah.
As the listing agent, and I'm asking these as I go, so these are right as they're written. As the listing agent, am I asking for proof of the buyer agent agreement to confirm the dollar amount the agent is asking for?
No.
You can ask for it. We've had this discussion in the forms committee. You can ask for it, but they're not obligated to provide it. Don't be surprised if some settlement attorneys may not ask for it. They may want proof to verify, especially at the early stages, because some agents still don't realize that you cannot get paid more than what your buyer agency agreement says. You would, unless you go back and modify your buyer agency agreement, which we have a form for that, were you to want to do that.
And also forgive me if I'm repeating ones because I'm reading these while I'm not listening to you guys. Does the buyer agent have to disclose that they are getting some compensation from the buyer?
Disclose to whom? To the seller?
I would assume.
No.
No.
They can make an offer and not have any mention in their compensation to a buyer's agent, just make an offer. And then that compensation is between the buyer's agent and the buyer. That's kind of the point of all this antitrust business that's been going on. And I think we might find, as part of the settlement process, I think we might find not so many of the combined Alta forms being used, and separate seller CD, and that only being given to the seller and the listing agent, separate buyer CD only being given to the buyer and the buyer's agent, and those numbers being kept more confidential.
If you're a listing agent and a buyer wants to be unrepresented, can you, the agent, decline to work with that unrepresented buyer? I'm being told it is a huge risk to work with an unrepresented buyer and that it is the seller's choice, not agent's choice.
I've heard some agents ask that question, Andy, and I would agree. I think we have to educate our sellers that a unrepresented buyer is in no one's best interest because they're not familiar with the transaction, perhaps. They're going to have more questions. They're going to be more likely to sue later, be more likely to have problems, perhaps. I mean, there's a lot of reasons why an unrepresented buyer is not necessarily in anybody's best interest. Got the rest of the question now, but I would review that with the seller. The question is, do I have to work with them? They're not a protected class that you can refuse to work with them. You can't discriminate against a protected class, but that's not a protected class. So I would say, based on our legal counsel, you could refuse to work with them.
And you don't have to work for free.
Absolutely.
I would answer this, except I don't know myself. Where's the Bright form they have to use? Where can they easily find that?
It has now been put in the DAR library as of, I think, last Friday. It didn't get in there initially. We wanted it in there, but I know in dotloop anyhow.
Yep.
In dotloop, it went in within the last couple of days. So it should be in the DAR library now.
And if you don't have dotloop,
you can go into Bright and you go to Bright. You've got to go through like 2 click-throughs to get to it. And I can't remember them off the top of my head, but from the main search screen, I forget now, but one of the links you click and you go down and it's got forms and something else, and it's the form right there. It is on Bright.
So we are dealing with a real situation that buyers are refusing to sign the buyer agency agreement and are canceling showing appointments. I understand you have to have a signed agreement, but is there another agreement that can be signed so that you can show properties?
Yeah, the antitrust settlement agreement requires, prior to touring properties, that there be some type of agreement in place. And if we find within the marketplace, that sounds like for that question, yes, but if we find within the marketplace that is happening a lot, of the buyers not wanting to sign the buyer representation agreement, even just for one day, which it seems to me to be the way to go, at least they have representation of that day. Then the forms committee is prepared to come out with a customer level service type agreement.
And I think further, the point that we kind of opened up with is that, this is all about realtors. We are going to focus as an association on non-realtors and this requirement in the future within the legislature, but that's a legislative task that we have for next year. So we haven't forgotten about that. As I said earlier, a lot of other states already have it required, so. Can the listing agent use the DAR forms when dealing with an unrepresented buyer? Also, is DAR coming out with any list of duties that an agent can or cannot do with an unrepresented buyer? Can we draft the contract for them in other forms?
What was the first part of the question again, Wes?
Can a listing agent
use the DAR forms?
Yeah.
Yes, if they're a member of DAR, as long as there is a DAR member involved in the transaction, they can use the copyrighted forms. Second question, I think, had to do with a list of things you could do with an unrepresented buyer.
Yeah. Now the duty of confidentiality still applies, and that's explained very well within the CIS. So you could go over that with the member of the public. And then, of course, you still comply with fair housing laws and things like that. But you're not their agent, you're not their advocate.
You can't exercise professional judgment or do anything that requires that. I would think when that question was asked a little earlier, I was thinking, well, suppose they said, will you send a copy of my agreement of sale to my settlement attorney? Mm-hmm. I would think you could do that.
Sure.
Because that doesn't require the exercise of professional judgment. But you're very limited. you're going to have to be careful.
Everyone, bear with me. 60 questions deep right now, and I'm not even close to getting to that 60 questions. Buyers come to an open house. Do we have them sign both a CIS and a buyer agency agreement, or in the MLS, tell any attendees to bring existing CIS and or buyer agency agreement with them?
Yeah, the Delaware law says that for an open house, you would just have the CIS available. I'd suggest, maybe by where they're coming in the front door and you've got some property description sheets there, you have a pile of CISs there, have the notepad where they sign in and give you a fake email and a fake phone number. They walk around the property, et cetera. If they ask you just for factual information, you don't have to present a CIS for that. So they say, well, gee, it says 5-bedroom, but I just saw 4 up there. Where's the 5th bedroom? Oh, it's over. Oh, okay, thanks. That's just factual information about the property. You don't have to stop them and explain about agency and the CIS and everything. But on the other hand, they start asking for advice. They say, "Wow, this is great. Can we make an offer today?" Then you're saying, let's sit down at the kitchen table and talk about it. At that point, you're having the CIS. You're explaining then about agency, determining is this going to be done as a dual agent, or are you going to just be representing the seller and do it that way. I suggest to you that you think about those type of scenarios before you open the door for the open house. You decide if someone asks for representation, am I willing to go ahead and be a dual agent in this transaction, or do I want to say to that buyer, well, no, I would not be representing you. I can help with go over the forms and show you what the blanks are, and you can decide what to fill in on the blanks, but I'm representing the seller. Now, if I was the seller of that property, I would want you to go ahead and be a dual agent, because if you have a buyer there who's sitting at my kitchen table on an open house day thinking they want to make an offer, I don't want you to be driving them away of saying, well, go get a buyer's agent to help you make that offer. I'm not going to be a dual agent. As a seller, I would want you to go ahead and be a dual agent. If that's a buyer there sitting there wanting to make an offer, and if being the dual agent is what it's going to take for doing that, I would do it.
Yeah,
I would want you to do
the
it.
statute on the CIS, nothing has changed there.
Right.
When you have to give it out, when you have to have it signed, everything's the same. And I envision that's a perfect time when you hand a CIS out and explain it. That's the chance to then go into the representation agreement. Okay, so I'm going to be a buyer's agent. Let me explain how this works.
Right. I'd be a dual agent.
I'd be a dual agent if it's my listing.
And that's all set up on the CIS for the dual agency.
As a sub-agent, can you use a compensation form that is included with the agreement of sale package?
I would say, if I'm understanding the question, the seller at that point is not going to be paying the buyer's broker. The seller is only going to be paying the listing broker. The listing broker is going to be paying the sub-agent. So you wouldn't put anything in the agreement of sale where the seller is going to be paying the sub-agent. The seller would pay their agent, who would then pay the sub-agent.
Well, it depends how it's structured. I assume at that point you would have already had a conversation with the listing as a sub-agent. You would have had a conversation about that with the listing agent.
Mm-hmm.
Yeah, you could still include it in the agreement of sale specifying sub-agent so-and-so will be paid X by listing broker so-and-so. You could do it that way to give you comfort of seeing it in there.
If the selling agent advises a buyer agent that the seller is offering 2.5 apples, can the buyer's agent relay this information to their buyer?
Sure.
Mm-hmm.
I know there's a couple questions in here about the sharing of commissions on other types of websites. I think it's important for everyone to remember that the commission can't be in MLS, and it can also not be in any of these other aggregators that are popping up. I know people are getting emails about different options available to them to aggregate commissions.
I got this covered. Just say no.
Well, here I can go further. The attorney that started all the lawsuits said they'll take legal action to enforce the settlement agreement on anyone that tries.
That's correct. So just say no. Don't be part of those. Let's try to work around this. Let's do this aggregator website. You don't need to. Just have your conversations with sellers, your conversations with buyers, make the offer, put a proposed request for compensation in there.
Do you want to cover anything about the rental side of this? Anything come up about that?
Well, the NAR settlement doesn't cover rentals or commercial. But rental and commercial are affected by the NAR settlement because Bright, who enforces the NAR settlement, has removed the compensation field on rentals and commercial as well. So even though the settlement didn't cover it, in practice, pretty much the same thing can apply.
If it's a rental that's on the MLS.
If it's a rental on the MLS, yes.
If you're,
And
If
by the
if you're
way-
going to tour a rental that's on the MLS listed with another brokerage, you're going to need a agreement with your tenant before you go show that property.
And the real estate commission CIS for rentals is being revised in the same way I showed you for sales.
if you're hosting an open house for one of your brokerage's listings, but you are not the designated agent on the CIS, are you representing the seller? And if it's not your listing, what is your responsibility to visitors of the open house?
I didn't quite follow all that.
Yep, if you're hosting an open house for
Right.
one of your brokerage's listings,
Okay.
but you are not the designated agent on the CIS, are you representing the seller?
Well, you've got the listing agreement that says that other licensees within the office can assist. So hold on.
Yeah, are you assisting the designated agent on their behalf, or are you just holding an open house as an agent and not representing the seller?
A good point was just made that I just saw that. And Andy kind of covered this right at the start, but some of these questions also are brokerage specific questions.
Right.
And we are noticing that's for sure. But always ask your broker, we're going to communicate with the brokers as much as we can. Maybe we'll have another special session for them. But some of these questions are brokerage specific.
I think when you're answering questions with the public, if I'm talking to a seller, I'm saying the neat thing about this is in the old days, you would say what you're paying me and what you're paying the other agent. And we don't know what the other agents negotiated and what they're allowed to collect. So why are you putting all your cards on the table? Just tell them, yes, you bring an offer, I'm open to pay a buyer's agent's compensation. So you don't need to put your lowest price or your bottom line on the table at the beginning as a seller. As a buyer, I know buyers are going to say, well, I don't want to sign this agreement. In some cases, that's what I hear, although I think in a lot of cases, that's not the case at all. But they say, I don't want to sign this agreement. Well, Mr. and Mrs. Buyer, now with business the way we have it structured now, you get to negotiate. You get to see what I'm going to provide, and you get to negotiate what I'm going to get paid. And I can't get paid any more than what you and I agree. So if the seller were to offer more, you can use that to your benefit. And so the seller's not giving money away. The buyer is negotiating and has power to negotiate. And as a broker, you're not offering any compensation. So you're off the hook from somebody saying, well, you were offering compensation, I want to be paid.
And you kind of going also down the rental road a little bit more. Tenants usually the co-broke, as stated in this question, is very uneven. And they are expecting more agents asking for a larger commission, more than 1 month's rent would cover. How do we deal with those requests on the landlord side up front?
We see this in Sussex County where the cooperation, the compensation to a tenant's agent is very minimal sometimes. Whatever that tenant negotiates with their representative, the tenant's agent, that's what they're going to get paid. And if it's more than a month's rent or if it's $20,000, it doesn't matter. Whatever they negotiate, they certainly can put that in the lease. Now, a lot of sellers aren't going to agree to it. Yeah, so they're wasting their time.
Regarding the CIS, keep in mind the CIS is a state form that's developed by the Real Estate Commission. There's a couple of questions regarding that I think sums it up. Can you confirm that if you are the list agent, can you confirm that if you're the listing agent, you can represent a buyer under presumed agency representation and dual agency versus the buyer choosing and initialing my designated buyer's agent only on the CIS.
Sure. Yeah, the Delaware Licensing Act and Rules and Regulations contemplate that the seller and the buyer are agreeing to agency representation and the dual agency. So you don't have to have the buyer initial anything then. There's no change in that procedure with the revision to the CIS. It just added the additional box for not my agent, I'm only a customer. But if that buyer is sticking with the presumption of buyer agency representation and the dual agency, then they're not going to initial anything. No boxes, just like before, not initialing any boxes. Just go ahead and sign at the bottom.
And sign a representation agreement.
Right.
Is it true that an agent working as a sub-agent cannot prepare an offer for a buyer because that is more than a ministerial task?
That's untrue.
You can do it, but it's really hard because that buyer is going to say, well, what do you think? Well, I'm not your agent. Remember, here's what the wording says on here. Here's a blank to fill in for a number of days or whatever it may be. And what would you like to put in there? Well, what do you think? Well, I'm not your agent. So you can do it legally, you can do it, but it's very hard to do it without falling into the unintended accidental, I'm acting as a buyer's agent. Looking like a duck, quacking like a duck, I'm a buyer's agent.
So a buyer opts not to be represented. Do you have them sign the new CIS covering that? You can now show them the home. No other forms required?
You can show it if it's your listing. If it's another company's listing, you're going to need to have and it's on the MLS, you're going to need to have the MLS agreement initial. And if they're not going to be represented, they're going to, of course, have to complete the CIS appropriately.
Sorry, I'm reading. There's some big ones in here that I'm not going to ask because they're way too long. This may be more of a Bright issue, but if DAR could counsel agents that if they do not enter into the MLS at closing what concessions were paid, if any, we will not be able to use the amount when we are doing a CMA for future clients.
I think we're going to have to talk to Bright about that.
Yeah, it's not on the MLS.
Let's see here. Okay, Bruce mentioned about broker not being liable for procuring cause. How do you envision a scenario if a buyer enters into more than one exclusive buyer agency agreement and sees same property with two different buyer agents? Do you believe there will be more enforcement of buyer agency agreements going forward?
That's very possible, but the listing broker, that's not a listing broker concern. That's a concern for the buyer's brokers, the two buyer brokers. And we've tried to make the form very clear that it's an exclusive agreement and it says you can't list it with another, or you can't enter into an exclusive relationship with another broker in that area for that type of service. But so that would be a dispute between in theory, they could owe both brokers compensation. They signed an agreement with both brokers. We need to caution them not to do that, just like we caution sellers. Once they've signed an exclusive agreement, they can't sign something with someone else, or at least they're not supposed to without creating additional liability.
How will a seller and buyer agree to arbitration if that's what they want to do? I don't think there's a place for this in the agreement of sale.
There's not,
Yeah.
That's correct. Yeah, if the seller and buyer want to have arbitration instead, you'd need a separate form for that.
Yeah, this is just between the brokerage and the client, those documents, nothing in the agreement of sale.
I'm going to ask this one. It's a little longer, but it explains it a bit more. An agent just closed a transaction. It was FHA when the actual buyer only had, I can say a number for the cost, right, Andy? Just not percentages.
Yeah.
Okay. Only had $5,000 cash, and we had to ask for $15,000 in closing costs. There's absolutely no way that he could or would be able to pay commission. What do I do in a situation like that? It goes further on saying, maybe the seller is not willing to pay me, and it is there anyway that I can have an agreement with the buyer saying that I will accept the fee that the seller is willing to pay. I know it is stated. Do you want to talk to that?
It has to be an ascertainable amount.
Now, if the seller offered a number and then you went back and modified a buyer agency agreement, you could do that and reduce the amount, but it's got to be a number. It couldn't say whatever they agree to pay. It's got to be an ascertainable number.
I know it is stated not allowed in the buyer's brokerage agreement, but is there anything to prevent a separate agreement giving the buyer some comfort, knowing that in case there's no money on the table, I would be willing to accept whatever the seller's asking.
Yeah, I think you can't just say, I'll take whatever they offer. It would have to be, you could, if the buyer's not able to pay your compensation and the seller's unwilling to pay anything, you could jack the price up accordingly. And if it appraises, you'd be okay that way, and have it deducted from the proceeds. You could, if you learned that the seller's willing to pay $2 or something, you could modify your buyer agency agreement to match that. Or maybe if your buyer doesn't have it, maybe you take a note or something and they pay it over time, pay you over time. But I would try to build it into price perhaps and increase the sales price accordingly if you think it'll appraise.
If the seller is offering compensation in the listing agreement and a buyer's agent asks, is the seller offering compensation? Do you have to answer? And if you do you need to tell them how much?
Yeah, so a buyer's agent's asking, is the seller offering compensation? Yes, you'd answer that. Because it would be in your seller's best interest to answer that. They've authorized the compensation. Why wouldn't you tell that to a buyer's agent?
In section 29 of the agreement of sale, in section 29 of the agreement of sale requests more compensation than what the buyer agent commission allows the buyer broker to collect. Does the seller still need to pay that full amount at settlement, or does it get adjusted down to the amount that can be used per the agreement?
The agent cannot collect more than the agreed upon amount in writing. And if agents start doing that, they're opening themselves to potential litigation and consequences, because that's a violation of the settlement agreement. You cannot be paid more than what your agreement says. Now, you can go back and modify your agreement and increase it if the buyer is willing. And we have a modification to buyer agency agreement. If on the other hand, they shouldn't be asking for more than what the buyer broker compensation is, because a buyer broker can't get paid more than what the compensation says in their agreement. If it is more, I think, well, I know one of our documents says that any benefit accrues. I think it's the listing agreement. No, buyer agency agreement says any extra accrues to the benefit of the buyer.
Yeah, unless
but agents should not be putting in a number larger than what they have agreed to in writing.
Right.
Because they're opening themselves to liability.
And that fax.realtor, realtor.fax? Fax.realtor, I've been going over so much. Fax.realtor, number 39 on that might address a little of this. If the seller or the listing broker offers a bonus or financial incentive in addition to the offer of broker compensation, can the buyer broker accept the extra compensation? Answer: the buyer broker may not receive compensation for brokerage services from any source that exceeds the amount or rate agreed to in the agreement with the buyer. But as Bruce mentioned, that could be amended. You could ask the buyer, would you allow me to accept this bonus they're offering for this weekend? The buyer could say yes. You can modify your agreement. The buyer could say no, and it's not modified.
Yeah.
The buyer is the one then in control of that, yes or no.
We've been asked that question a lot on new construction, where some builders, the more homes you sell in a given year, the higher percentages they pay or the bonuses they pay. And you can only receive that if you go back and modify your document. You can't be paid more than what you're negotiated with your client.
So prior to August 17th, you ratified a contract and displayed a number for compensation. Do you deduct or add that seller provided compensation to your buyer agency agreement upon compensation?
If it was under contract before, it's governed by whatever the offer of compensation was in the MLS.
If you have a buyer agency agreement for a commission and the compensation offer happens to be more on the property you're offering on, they did say we can modify for the difference through our buyer agency agreement at that point if the buyer agrees.
Yeah, do a modification to buyer agency agreement.
When a seller's
And we have a standard form for that.
when a seller says they don't want to pay a buyer a concession towards closing, but want to pay a buyer's agent a percentage, should they state that on line 25?
They
Number
can,
25.
if they want to say, I'm going to pay this and offer it to a buyer's agent, they can put it there. Or they can just, as we would recommend, go into concessions and check yes. And we'll negotiate it when the offer comes in. They could do either of the two.
Does the bright disclosure, is it only for buyers to sign or sellers also?
Both have to initial the top part. And it tells what Bright is and how it works. Buyers and sellers both initial the top part. Now, the bottom part is for sellers, and they'll initial one of the four options. Is it coming soon? Is it a company or office exclusive? And it asks when the actual date that the public can learn about it. And you want to check that form. I see a lot of questions about, when does the 2-day clock start on Bright and things like that. In that Bright addendum, down about 2/3 the way down, it says, when will the property be publicly available or available for the public to learn about? And that's the day that within that date, that's when you can put it on the system. Within that date, you have to have it in there within 2 days. That's the day that even though you got a signed listing agreement, you can't market it till that day. That's when the public can learn about it. And that's when the 2-day clock starts.
And let me go back a little bit to, again, the FAQ. I encourage you to take a look at FAQ 61. I'm not going to read the whole thing, but the question part is the practice change requiring written agreements with buyers is triggered by 2 conditions. It only applies to MLS participants, quote, working with, end quote, buyers, and is triggered by touring a home, quote, end quote. What does it mean to be working with a buyer? I'm not going to read the first part, but this addresses some of a question that come up a little bit ago. If the MLS participant is working only as an agent or sub-agent of the seller, then the participant is not, quote, working with the buyer. In that scenario, an agreement is not required because the participant is performing work for the seller, not the buyer. You'd use the CIS though. Authorized dual agents, on the other hand, work with the buyer and the seller. So then you would be using the agency agreement as well. So,
Do you need to let your clients know before you turn down an unrepresented buyer?
yes.
Yeah, if your client was a seller, yeah.
Thank you for everyone that's telling me where the Bright form is. So it looks like it's easy. It's under the Bright menu policies and Bright MLS rules.
Great.
Any suggestions for property managers about buyers agents compensation? Do we use the same language that buyers and sellers are using?
Property managers. Are you looking, if you're looking at it from a rental world, once again, the NAR settlement doesn't affect commercial and rentals, but in theory, Bright has made the changes in the fields of compensation. And so you could treat it very, very much the same.
In dual agency, does the buyer also sign a buyer agency agreement agreeing to pay compensation? If so, why is the seller offering to pay extra compensation on page 2, section 10A of the listing agreement?
Well, what will happen is if the buyer signs a buyer agency agreement agreeing to representation, which would make you a dual agent, in that buyer agency agreement, it's going to specify the compensation for that side. Your listing specifies the listing side. The buyer agency agreement that the buyer signs, making you the dual agent, that's going to specify what you're going to get paid on the buyer side. So that would be a separate written agreement with an amount that, if you intend to be paid, an amount of compensation.
Yeah, let me go back to the ministerial acts question. In the FAQ 67, are written buyer agreements required when MLS participants perform ministerial acts? There's a yes, kind of a yes and a no. Okay, so yes, the obligation to enter into a written buyer agreement is triggered just prior to an MLS participant taking a buyer to tour a home, regardless of what other acts the MLS participant performs for the buyer. Next point, though, an MLS participant performing only ministerial acts and who has not taken the buyer to tour a home is not working with the buyer and therefore does not yet need to enter into a written buyer agreement.
At settlement, there is no compensation from the seller and the buyer is short of funds. Would the settlement still occur even if there's not enough money from the buyers to pay the buyer's agent full fee?
You do settlements, Andy. I think the brokers are going to be having a conversation.
You're gonna have to work, you're gonna have to work it out. And by the way, that's way down the road because you're getting to settlement. But I can imagine a scenario, folks, where, and this kind of was alluded to in a previous question, you've agreed to a certain amount of compensation that the buyer's going to pay you as a buyer's agent. You get down to the brass tacks of negotiating that. You've properly included that in the offer that the buyer's making. The seller comes back and says they're not willing to pay that much, but they'll pay something less. You're having discussions with the buyer then, of the buyer then paying you the difference. And the buyer says, well, I just can't do that, or you're still going to have more discussions. I think it would be helpful at that point if you had some type of a log, and I know there's some apps being developed, but you could pull up right then on your device to say, well, you might not be aware, but do you realize we've been working together for, it's 9 weeks now, and we've looked at 40 properties and we've made an offer on 6, and just have a rough idea, and then say, so you're asking me to. You realize that would mean that I'm making less than minimum wage, and maybe then they're willing to, you work it out. So I think it'd be helpful, even though you're paid a commission or a flat dollar amount, it'd still be a good idea to keep just a rough idea of how much time you spent with the particular buyer. So if that request comes up, you yourself know, all right, well, I'm willing to compromise on this. I am or I'm not. Unfortunately, I just have to work it out.
A recent study shows that most buyers think that we spend only a certain amount of time. And I don't recall off the top of my head, it was like 15, 20 hours or not much time working with them. When in reality, the same study showed that most of the buyer's agents spent between 80 and 100 hours. And so a lot of times, as Andy suggested, if you have a track, buyers have no idea what we do for them.
Right.
When they're not sitting in front of us, they don't know what we're doing in research and negotiation and all that type of thing.
Mm-hmm.
Can you discuss the addition of a yes/no checkbox under arbitration?
Sure. So it's just offered as an opportunity for the agent and that member of the public to say that they would rather arbitrate if there's disputes just between them, not with the other party to the contract, but just between them, rather than going to court over that, or rather than participating in a class action lawsuit. What else to say about it? It's optional. It's yes and no, so it's optional. The broker doesn't have to.
We had asked, as a forms committee, we asked Andy, are these arbitrators available? If people check yes, are we going to be able to find these trained arbitrators? And we've been assured that they are.
Yeah, there's a lot of, pretty much any real estate lawyer would probably be willing to, offer perhaps that opportunity, or there's arbitrators through the American Arbitration Association. So arbitrators are available.
You said that if the seller checks no on concessions, that indicates the seller is not willing to give compensation to the buyer's broker. I was told concessions and compensation were 2 different things.
Well, they are, concessions is kind of the umbrella term. So that could include buyer agent compensation, repairs towards a roof, repairs towards a new septic system, whatever it may be. So seller concessions is the umbrella term. As I think we indicated before, if you're representing a buyer and, I'd show that home anyway. It might be the perfect home for that buyer, and just make the offer accordingly, whether that offer would include a request for seller concession that could be applied towards buyer compensation, or doesn't, just as long as the buyer knows, okay, they're making an offer on that property. If the seller's really not willing to pay any seller concession, then the buyer is offering this rather than this, and buyer's agent getting paid that from the seller. The buyer's just making the offer here and realizing they're paying their agent compensation here. So it's still that amount. So just like we indicated early on in the scenario I set up with Bruce, on the seller side, you're the professional doing a seller net sheet. On the buyer side, you're doing a seller gross sheet, if you want to call it that. Total amount of buyer would be paying, transfer tax, the whole bit.
On the listing side, it would all fall under concessions, yes or no. It's in the sales agreement that we've separated it. And a buyer's broker compensation is a concession, but we've separated it out because it's not included in the limits that the interested party contributions, that limit that most lenders have. So that's why we've separated it out there, so it doesn't further limit the amount that can go there. But from a seller standpoint, they're all concessions.
If the buyer agency agreement is one amount and the seller offers higher, will the agreement of sale asking for the higher amount supersede the buyer's agency stated lower amount?
Yeah, the exact opposite.
The buyer's agent cannot be paid more than is agreed upon in writing, period. And agents need to get that very clear. You cannot be paid more than your buyer agency agreement says in writing, period. If you need to modify your buyer agency agreement, modify it. Do not take 1 penny more than was agreed upon, though, without modifying it with the consent of your client.
This is a little broader question, but I'll ask it anyway. Have you heard of any lenders coming up with different plans to roll buyer agency compensation into the buyer's loan?
The lenders that I'm hearing from and talking to are prepared to allow sellers to include it or pay it out of the proceeds, to separate it out of the other interested party concessions, which are usually like 3 to 6% that the lenders will allow. Most of them seem to be aware of what's going on and willing for it to be included in the offer to purchase. Included in the sales price. Most lenders seem to be on board with that.
Yeah, going back to the previous question, the FAQ 74, MLS participants may not receive compensation for services from any source that exceeds the amount or rate agreed to in the buyer agreement. Does this mean that brokerages can only have one agreement with the buyer? No. The practice change empowers buyers and buyers brokers to negotiate and agree to services and compensation that work for them. Participants should work with consumers to ensure they fully understand the options available. Compensation continues to be negotiable. At times, a new or amended buyer agreement may be appropriate, as we indicated, and the buyer and broker may agree to amend the terms, blah, blah, blah. So it's good source here.
If an agent, and by the way, we promised everyone 3:30 that this would end. We have a decent amount of questions left. We'll try to still knock through a few of them. If a listing agent gets in writing that the seller will pay buyer broker 2.5 apples, and in the agreement of sale, we say the seller is to pay 2 apples, will the listing broker get that, or does the seller keep the extra 0.5 apples?
The seller's paying less than what they said they pay, so that is.
I think you got to be careful when you have a broker offering one compensation and then you got something else in the agreement of sale, and it can very easily start to get confusing too, where you think you're getting something and you're maybe getting something else. I would make sure everything was very clear. That's why it's cleaner just to put it in the offer to purchase, the agreement of sale. Nothing prevents you from offering compensation to a buyer's agent. As we've said, the NAR agreement allows that, but our form is designed so it should be incorporated in the agreement of sale.
Can I have in my listing agreement that the seller will pay me 3 apples for the listing and 2 apples if I am representing a buyer as a dual agent, but not commit to that 2 apples to other buyer agents?
And that's what you negotiate in your listing.
Yeah, but then you're going to need to also have a buyer agency agreement.
Right.
And maybe the buyer negotiates 1.5 apples. So the 2 apples the seller offered doesn't matter. You're only going to get 1.5. You tell the buyer that they offered 2, and the buyer's going to say, well, then I'll take the other half. I'll take it as a settlement credit.
Is it acceptable in a buyer's agency agreement to have 2 different fees, such as an amount for a resale and a different amount for new construction?
Sure, if that's what you
I've had people in builders down in Sussex. I know, Andy, some builders offer different rates and compensation packages. And I've got agents that will say, here's what I charge, but if you buy one of this builder's homes in this community, it'll be this.
Right.
But that is an ascertainable number.
Right.
I think you covered this in your example earlier, but can the new exclusive buyer tenant agency agreement impact a claim of procuring cause when it comes to compensation between competing agents or buyer and agent?
Yeah, if you haven't seen it, and I realize all of this going on is probably leading to more discussions about procuring cause, but encourage you to take a look at the NAR Professional Standards Manual, and within the arbitration part, they have arbitration worksheets. So if you've never been part of an arbitration panel, that's one of the tools that is usually used during an arbitration hearing. I think it's about 40 different points that are considered within that, as far as a worksheet to try to help determine procuring cause. And that's available to you. You just go on the NAR website, you can download the whole manual and take a look at that worksheet.
So,
Or a broker can offer no compensation, period, and have less liability, which is the way our form is designed.
so buyer agency agreement signed. Seller is offering a bonus that exceeds amount negotiated with buyer. Does the buyer agency agreement have to be modified before the offer is accepted by seller with the higher compensation, or can it be modified after agreement of sale is signed?
If it's in the agreement of sale, trying to have the buyer's agent be paid more, then you'd need to modify the buyer's agency agreement before the buyer accepts that offer, I would think.
That would seem the cleanest, certainly the cleanest approach.
Question correctly?
Yeah, better to change it rather than go back and try to, after the fact, change it so you're in compliance.
Thank you to the broker that submitted this one. Can you touch on the fact that an agent does not have the legal right to enter into a sub-agency with a different seller and brokerage without the parties to the other side agreeing?
Right. Yeah, the seller doesn't have to offer a seller sub-agency.
Paragraph 12 of the listing agreement. Do you have that there?
I do.
A does not have a yes or no box, but B does. If they say no to B, are they denying cooperation? Shouldn't A also have a yes box?
No, A is presumed. The way our listing agreement is prepared, A says we are authorized to cooperate with buyer's agents. And the code of ethics says we'll always cooperate unless it's not in our client's best interest. So A says we will cooperate with buyer's agents. That's the same thing it said before we came out with this version. The only question is whether we'll cooperate with sub-agents. That's the one that's the question that has yes, no. A is presumed to be yes, it's automatic.
Why are we saying that repairs can be part of concessions? That should be dealt with in the home inspection like it was. The two should not be mixed, in my opinion.
Well, sure. Yeah, I didn't mean to confuse things there. That would be if upfront the seller is saying, maybe they know as part of the listing of the property that it's going to need a new septic system. So maybe right up front, they're disclosing that and they're saying, seller offers $20,000 towards the new septic system. They'll cooperate together to design it, whatever, things like that. So that I didn't mean to say it was not going to still happen through the home inspection process.
Before writing an offer, if I call the listing agent and ask if the seller is offering buyer compensation, I assume they don't have to disclose the amount, so they don't give away more than necessary in case the buyer would have asked for less. Question.
Right. Well, you'd want to have that discussion with the seller as far as what you're authorized to say and respond accordingly. And Bruce, what do you think?
Yeah, I mean, the seller's going to authorize in writing, here's what I'll do.
Right.
Here's what I'll pay a buyer's agent. So if you called and asked, I would tell you what they said they would do. As Andy says, I'd have that conversation with the seller. Mr. Seller, maybe you're best not to tell them what you'll do up front. Maybe you're best just to say, yes, I'll consider concessions.
See what
That's the way the form's designed.
See what the offer says.
Yep.
Buyer refusing to pay buyer broker and request the seller to pay commission. What recourse will buyer's agent have in that scenario?
What was the question again now? Was
You're going to have a written buyer agency agreement and you can enforce that according to what it says.
Yeah.
How would you suggest adding in brokers' management fees when writing up the buyer's representation agreement with a buyer?
Like if you have an administrative fee or something,
Yeah,
I think our buyer representation agreement has a provision for that. Under compensation, it says compensation of a percent of the gross selling price / lease or amount of flat fee plus. And then, so say you're charging 8 apples, plus you're charging an admin fee or a management type fee, that would go on the second line there, that would be plus.
Believe it or not, I got through all the questions. I'm going to ask the ones that went to the wrong place. So I'll tackle a couple of those because we'll have a couple more minutes here. So bear with me here. Maybe we did get most of them. Give me 1 second, everyone. I just want to try to get as many as I can answer for you all. Luckily, a lot of these actually were answered.
I think a lot of the questions that I've received over the weekend are from sellers who want to continue to offer compensation. And can I do that? And yes, you can under special terms. A settlement agreement would say that. Although I will tell you the Department of Justice says it's not in the spirit of the settlement agreement, and they argue for decoupling, and that's the way our form's designed. So, I know your seller wants to offer compensation. That's in their best interest, I believe, as a broker, because it opens the property to a larger pool of potential buyers. But why would they put their cards on the table, what they're willing to pay? They're better off to let the buyer negotiate what their agent's going to get paid and then include it in the offer.
Well, Wes is scrolling through that. Let me touch on another topic. So as part of the settlement of the class action lawsuit, there will be notice to class members coming out. So that will include people in Delaware. And NAR, I think it was last week, came out with a pretty good tool, a pretty good information sheet that you could provide. So you will start getting questions from sellers you'd previously had their property listed. Hey, what's this? I got a notice about some lawsuit. I hadn't heard of that. And believe it or not, there are people who haven't heard of it yet. I'd suggest just download that sheet from NAR and you can provide that to them, and that directs them to where they can get more information. Also, as Bruce mentioned, the Department of Justice, within the timeline of all this, the final approval by the court won't come until later this year. And so the Department of Justice still has the opportunity to file what they call a statement of interest, basically their own brief, if you will, about their comments on the proposed terms of the settlement agreement. So we've gotten this far up until the August 17th implementation of all the practice changes, but the Department of Justice still could put in a statement of interest as to whether they agree or disagree with these various terms that we've been working on and complying with. As Bruce said, we tried to be forward-looking in Delaware. We've studied the statement of interest that the Department of Justice filed in Connecticut, the Penn antitrust lawsuit up there. We studied that. We tried to position ourselves in Delaware to be complying with what we think could be a statement of interest filed by the Department of Justice. But don't be surprised, we might be back in another month or two talking about some additional revisions. So we're staying on top of it.
And Bright, pretty much everything we've done or how we've drafted our agreements, Bright has followed the same course. So our entire region, pretty much, the MLS is tailored that way. Someone asked a question, and Wes pointed it out. It's in section 10, which is compensation in the listing agreement, 10A section 2. Well, 10A is the listing side compensation, but there's a second paragraph in 10A, and that says, seller acknowledges that the buyer may choose to be unrepresented. In such event, the listing broker may need to perform additional ministerial tasks that would otherwise be performed by a buyer's broker if they had representation. Seller agrees to pay listing broker an additional compensation of, and it lists that. So the first paragraph of that section 10 is, what are you paying the listing side? That's what I'm negotiating with the seller. Now, Mr. Seller, it's possible that a buyer may come in and say, I don't want representation, Bruce, but I want to buy your listing. All right, so you're going to be a customer. But I'm going to have work to do, and I'm going to have to answer questions and make photocopies and stuff like that, ministerial tasks. Am I going to do that for free, or is there going to be a charge?
And that's negotiable.
And that's negotiable. And there's the line where you would put it if you're going to charge. are supposed, and here's another scenario, suppose I have a listing and another agent in my firm is working with a buyer who chooses to be unrepresented. All right. So I've got the listing side coming in. What are you going to pay that other agent in my firm who's working with a customer, a unrepresented buyer? Well, in this case, if I have a number there, I'd have some additional funds to cover that additional work. That's why we have that second paragraph in the listing agreement in section 10A.
I'm going to ask two more questions. One point I do want to make for the benefit of everybody, since we still have a large number on the call. The way we kind of started this conversation was about all the different places information is coming and flowing from. And a lot of this will boil down to office decisions being made. Your broker making a decision about how practice is going to happen at your office moving forward. We're going to focus from DAR's perspective on communicating really to brokers on this moving forward for the moment. We do not want to confuse too much. And I think, at least I'm saying it right now, I think the best course of action moving forward, instead of having big sessions like this, that we're going to be focusing more on direct outreach to brokers and helping them help individual agents. So just wanted to put that out there real quick. And these last two questions. Brokers are advertising compensation that sellers will offer to buyer's broker on their own websites. This is what we're being told will be necessary. Your thoughts?
Well, they can do that. I mean, that's permitted.
Not
It's not
required.
required at all.
Just permissible.
Yeah.
And just to clarify, if you're touring new construction, should we put the max that some of the builders might be offering, like blank percent, and do a modification once the buyer picks a home?
So it's a matter of what you negotiate with the
Yeah,
buyer.
whatever you're willing to accept. You can always modify it by mutual agreement. And you can, of course, always take less than you agreed upon, but you can't take more without a modification to your agreement.
I'll get two more in here, sorry. Will the attorney collect the buyer's payment and disperse it to buyer's broker at settlement?
Yes.
Our form says the attorney is irrevocably authorized and directed to collect it and pay it in accordance with the listing agreement and the buyer agency agreement. Says that right in the agreement of sale.
And as a realtor, do you have to fill out a buyer agency agreement if touring properties
For yourself?
for yourself?
I didn't quite understand the question.
If you're
Oh, you yourself.
yourself, yeah.
Oh, sure. Yeah. Then you're the client as well.
Yeah. Yeah. And you'd have to talk to your broker and see what kind of compensation they want or how they want to handle that.
All right, folks, I think I got through most of them. There was maybe two or three I did skip because they were extremely long. So please, I put our email address, info@delawarerealtor.com in the chat box. If you have further questions after today, feel free to send them. But again, please talk to your broker first. That would be the best course of action. Andy, Bruce, did you have anything you want to close out on?
Yeah, I'd like to mention the Delaware Real Estate Commission. I'm real pleased that they are participating again in the ARELO process, Association of Real Estate Licensed Law Officials. So just like we're working on trying to keep up with things, they're keeping up with things and they're getting a lot of information through ARELO as to what's happening in other states and issues. So the Real Estate Commission is doing a good job there.
I would add one additional item with the Real Estate Commission. Most of you, well, you might be finding out post the September meeting, there may be additions to the seller's disclosure forms. So keep an eye out for that. We'll send them obviously out, notify you as a membership, but you would hear that also from the Real Estate Commission themselves. Yes, this session has been recorded and hopefully it all worked and it's being recorded, so it'll be uploaded as soon as possible. Bruce, anything else?
No, just remember the NAR settlement, you must have a written agreement before you tour other companies' properties that are on the MLS. And you cannot be paid more than the amount that is specified. The way our forms are designed, we encourage, you don't have to do it this way, but we encourage the seller negotiate what they're going to pay, buyer negotiate what they're going to pay, and if the buyer wants it included, to put it on the agreement of sale and say the seller will pay it on my behalf. Seller agrees to pay it. And all the wording is there. And the MLS documents I mean, you can get copies of news articles about this. You can put together a little booklet if you want, or a presentation that you can present to buyers and say, look, it's not Bruce saying this. Here's Delaware Today. They had an article this weekend. Here's National Public Radio had an article this past weekend. So this is not just here, it's nationwide.
And
Doesn't matter where they go.
And NAR has some good fact sheets for buyers and sellers, members of the public. And what does this settlement mean for me as a member of the public? So you can use those tools.
Yeah. And in the NAR settlement, a seller can still agree what they're going to compensate. You could still put that in special terms, but the form's
Not on the
designed,
MLS.
not on the MLS. You can't put it on the MLS. But we're encouraging the form's designed so that you would negotiate that with the buyer client and then put it in your offer to purchase. But the NAR settlement does allow the seller to say what they'll offer if they choose to, if they want to put their cards on the table.
All right, Andy, Bruce, thank you so much for your time today. Thank you to all our members that joined us. Again, info@delawarerealtor.com with additional questions. And that's it for now. Thank you all. Have a great day.
Thanks, everybody.
See ya.